Dear Heavenly Father, Lord, creator of all things, we come to you this afternoon, Lord. We just thank you for this beautiful day you've given us, Lord. We just thank you for the patience and the courage you've given us to consider this issue at hand, Lord. We just pray that you would be with us, give us clear, concise, and meaningful thought as we give these items of deliberation, Lord. Just be with our brethren, be with our people. Continue to bless us in all ways that you see fit. In Jesus' name, amen.
Thank you. The purpose of this meeting is to ratify a resolution covering the memorandum of agreement between the Cherokee Nation and the Delaware Tribe of Indians. And Dr. Cobb, are you sponsoring that and going to present it? Or okay, the floor is yours.
We need roll call.
Yeah. Oh, are we going to do roll call? Probably a good idea.
Let's make sure we're here.
Meredith Fraley.
Here.
Bill England.
Here.
Bill John Baker.
Here.
Jack Baker.
Here.
Harley Buzzard.
Here.
Julia Coates.
Here.
Bradley Cobb. Joe Crittenden.
Here.
Jody Fishinghawk.
Here.
Janelle Fulbright. Don Garvin. Chuck Hoskin Jr.
Here.
China Glory Jordan. Curtis Snell. Chris Soap.
Here.
David Thornton. Kara Callan Watt.
We have a quorum. Now, Dr. Cobb, the floor is yours.
This is a resolution ratifying the memorandum of agreement between the Cherokee Nation and the Delaware Tribe of Indians. Upon ratification with this MOA with the Delaware Tribe of Indians, the purpose is in order to protect to the fullest extent possible the territory, jurisdiction, and sovereignty of the Cherokee Nation, while also providing for the federal recognition of the Delaware Tribe of Indians. And that a limited waiver of sovereign immunity is hereby approved for the specific purpose of enforcing the provisions of the MOA as long as the MOA includes an equivalent waiver by the Delaware Tribe of Indians. And I move for approval.
Second.
Moved and seconded. Discussion? Mr. Hoskins.
I have a question about the arbitration provision. So, and I don't want to step over Madam Secretary if she was going to give a review, so I can certainly hold my question if she was about to give a review.
Did you want to give an overview?
I'd like to, Madam Chair.
So I would yield.
The floor is yours now.
Thank you, Madam Speaker. Before we get too far along, I'd like to ask the Principal Chief to make some opening remarks about the agreement and where we've come from and where we're headed.
Chief Smith.
Thank you very much, Madam Chair. As many of us understand that the Delawares and Shawnees were incorporated into the Cherokee Nation in the 1870s. We have different versions of history and different versions of the status of the Delawares and Shawnees at that time. Unfortunately, over the last decade, it's been litigated all the way to the U.S. Supreme Court. First year I was in office, I met with representatives from the Delawares and discussed principles on how we could resolve the situation. We, as a tribal people, understand the affinity that each tribe has for its own heritage and culture and traditions. And so we worked with the Shawnees, and they were able to obtain by statute separate federal recognition. And at that time, almost a decade ago, we made the same overtures to the Delawares. And the driving fundamental principles is that we would protect at all costs the boundaries, the jurisdiction, the territory, and the sovereignty of the Cherokee Nation, as expressed in 23 treaties and fee patents in 1838 and 1846. That in essence there was only one tribal government within the Cherokee Nation that had preeminence, and that was the Cherokee Nation. Unfortunately, after those initial overtures were made, there was a disagreement about dismissing a case that was then pending. Instead of being at the negotiating table, the administration then of the Delaware tribe accelerated the litigation, and that led us to a point several years ago when their claims were denied by the federal U.S. Supreme Court. with a new administration that was far-sighted and open-minded, we were able to sit down at the table again and begin to renegotiate the relationship within the Cherokee Nation, of the Cherokee Nation and the Delaware tribe. We acknowledged that what they would do as a separate federally recognized tribe outside the Cherokee Nation was not our interest. The interest that we sought to protect and preserve was other tribes operating under some color of character within the Cherokee Nation. Chief Douglas and his team have been very diligent in pursuing those principles and coming up with a resolution. John Sullivan introduced several weeks ago a bill in Congress to acknowledge the Delaware tribe as a federally recognized tribe, subject to our concerns and interests around preserving and protecting the sovereignty of the Cherokee Nation. The agreement that is placed before you today is an understanding between us and the Delawares as to how that relationship would operate. And we believe it's a fair way to deal with those historic issues. We can determine that relationship today, anticipate contingencies in the future, plan for those, and allow the Cherokee Nation to have proceed with its sovereignty unfettered, but at the same time affording the Delaware tribe its autonomy that it's so earnestly desires. So I think what we have in front of us is a good agreement, and that Melanie and I are very anxious to answer each and every one of your questions, because even though we have disagreement on occasion, maybe been more than one occasion, I can say this is one thing that I firmly and sincerely want to be in concert with the council. We need to be very comfortable with it, and I think the agreement we have brings us to that comfort level, and I'm anxious to get this stage of a relationship with the Delawares over so we can go into more positive things. So, any questions or comments, or I can defer to Melanie.
You want to refer to Melanie?
Any now?
Questions or comments for Chief Smith? And Doug, who do we have on the conference call?
Chief Douglas.
Chief Douglas?
Yes, ma'am.
I guess they have no questions for you. They probably want to hear from Melanie.
They want to know from who knows something, right?
Also want to introduce Vicki Souza, who's here from Delaware's, and she's an attorney for them as well, so she was able to come be with us today. Welcome, Chief, Deputy Chief from Delaware's. Can you hear us?
Not real well, but greetings to y'all.
Okay.
I'm hard hearing, so.
Can you hear me now?
Yeah, I can hear you, but
Well, we can hear you well. I'm moving a little closer, so that should help. Okay, what I'd like to do is just walk briefly through the agreement. The speaker was good enough to send some comments to me in writing where I can raise some of those issues that she raised in her comments and hopefully address some of those. What I have for you is a red line version of the agreement and Lita will hand that out, that addresses about 3 of the specific issues with additional proposed language. I was able to get with the Delaware attorney and we were able to come up with that language before this meeting. So we'll have that for you as well as we go through. The first issue, just briefly, the first page concerns general purpose, some overall historic language about the agreement that we entered into in 1867, some definitions of the nation's jurisdictional boundary and so forth that become important in the agreement. But the first issue where the speaker raised some concerns was part 2, that starts on page 2, called dispute resolution and enforcement. And if you look at part A under that first 2 there, that begins the paragraph to preserve the balance. The speaker's comment here was this 30-day receipt notice of once we identify that there's some dispute. We agreed that we would meet within 30 days of identifying that. And the comment was, well, what if one party refuses to meet within that 30-day period, then what happens? So what we assumed was that either party could take a dispute either to arbitration or litigation as provided in the agreement. So what we did here, if you notice on the red line version, is that we added a sentence that just clarifies that. If a party refuses to meet within 30 days, either party may proceed to litigation or arbitration under Section B, just to be clear that we can move forward even if we don't have this meeting. The next part of this section deals with enforceability, and we talked long and hard about enforceability provisions because we know with some of our dealings with other tribes within the Cherokee Nation that enforceability is an issue. What if a tribe that, and I unfortunately used United Kituwa Band sometimes as an example in my dealings with the Delaware, only because of gaming, only because of jurisdictional issues, competition on funding, competition for, say, even intergovernmental arrangements, and how would we deal with those things? And then if something is breached by either party in this agreement, even if we come to agreement, how are we going to enforce the provisions of the agreement? We also had, as part of our experience, the recent tobacco arbitration, and that was in our minds as we went through this. Even if we have arbitration as an option, we want to make sure that there are some other things in place that one, if perhaps we don't like the outcome of the arbitration, what happens, or is there anything that we can do as a result of that? Two, whether there would be damages or not damages as part of an arbitration process, and so forth. So those things were, prevalent in our mind as we went through this. So essentially what this provides, as you review the agreement, it provides for either party to pursue arbitration or federal district court as an option for enforceability of the agreement. If arbitration is pursued, it is not binding if a party wants to take it further. So if there's an arbitration decision and one party's unhappy, they can within 30 days take that to federal district court and seek another level review of that. If they fail to do that, then it does become binding at the conclusion of that. The other thing that, and this was in the speaker's notes, and it was a very real possible outcome, is what if the federal district court determines it would not have jurisdiction over this agreement? So we could pursue federal district court all day, but they don't have to take up our case, essentially, is the reality of it. And so acknowledging that as a possible outcome, what we've done is it's on page 4 of the red line version, and you'll notice the red print there. That was an addition that we thought if this outcome does happen, the federal district court determines it doesn't have jurisdiction and will not hear the case, then we would want an arbitration process to be final, that becomes the end of it, it becomes binding on the parties, and that we've resolved the disagreement. And so this language that's added here, the first sentence essentially says, if a federal district court concludes it does not have jurisdiction, then arbitration is binding. And then the second sentence deals with if the federal district court finds it lacks subject matter jurisdiction to reach the merits, but could review the enforceability of an arbitration decision, that it could go ahead and decide the enforcement of the arbitration decision. So that's what that additional red language would do.
Melanie, Mr. Hoskin, did you have a question?
Question to this, if I could.
Yes,
If we say this is binding, there's still an enforcement question. Won't there always be an enforcement question?
I think there pretty much would be, and we tried every method, and I would invite Tom, if you're on the phone, or Vicki, in our discussions, we acknowledge that even though we say it's binding arbitration, what if one party chooses not to follow it? And I think we're going to have that issue. We could pursue it in federal district court, but what if the federal district court decides not to take it up? Then binding arbitration really doesn't become binding because one party can just disregard it.
Do we have a sense of what we think the most likely outcome will be if we go to federal district court? It seems to me the issues would be limited before. If the federal district court said that they had jurisdiction, it would be limited to some specific areas, not a de novo review, which this calls for. I just wonder, do we have a sense of what we think the likely outcome is going to be? And maybe it's because it's uncharted territory, we don't know. But
I'd invite any of the attorneys to weigh in on this one.
I think the real remedy that this creates is an injunction, a declaratory action under injunction. And basically, when we get to federal court, could ask for a decision on this issue and then invite an injunction to prohibit the Delawares from pursuing some aspect of federal recognition, or the Delawares could likewise pursue us for not supporting that or changing our course.
do we think it's more likely that the court will say, we're going to do a de novo review, we're going to look at this thing all new, or do we think it's more likely they're going to say, is there some abuse of discretion on the part of an arbitrator? I just wonder what we think the likely outcome of that is.
Well, I think the standard of review, since we've cited the arbitration standards, it would be a capricious and arbitrary review by the federal district court.
And if at the end of the day, the Delawares or tables are turned, we break this agreement and we say, well, it's final and binding, there's really no means of enforcing it other than both sides having, good faith and saying we're bound by this, we're as good as our word. No neutral arbiter is going to come in and say, you better be as good as your word. Is that the case?
I think there's two aspects to this agreement. One is pre-recognition and one is post-recognition. Pre-recognition is probably the part that should be of greatest concern to us. And basically, if the federal court does not enforce the agreement pre-recognition, the great power there is lobbying. Congress and administration, that the court has found Delaware's breached, or the Delawares could say the Cherokee's breached, and that should enter into the political decision of whether to grant or to fashion or to no federal recognition. So I think there's a practical side to it besides the legal enforcement side to it.
Chief Smith, this is Tom Peckham. Can I interject something?
Yes, please. And who was it?
This is Tom Peckham, and he was the primary attorney negotiating this agreement with Delaware.
The other thing to remember is that there's also going to be if for example the Delawares receive money from the United States contrary to this agreement, there may also be court jurisdiction in a tribal or state court over that thing itself, not over a party to it, but over the thing itself. And so there may be an additional avenue to enforce breaches of the agreement that relate to, and this is the most likely post-recognition issue, is that we disagree on what Interior should have done with a pot of money. And a court might be able to reach the pot of money independently of the whole federal court arbitration provision in this part 2.
Mr. Osborne, you still have the floor.
That's all.
Okay. Continue, Melanie.
Okay, moving back just a bit to, it's still on page 4, but it's at the top of page 4. It's the big V at the top of page 4. In the original agreement that we sent you, there was a last sentence in there. And we're proposing to remove that sentence, and I'll explain why. The speaker sent us a comment about money damages, and we purposefully sought to avoid any type of money damages either in the arbitration phase or in the federal district court phase for either party. So if there's a breach and there's found to be a breach, money damages can't be part of the remedy. What this sentence did provide, though, that reasonable expenses could be imposed on a party. And what that would mean is attorney fees or other kinds of costs. And so what we did was also eliminate that from this agreement, or we would propose to, if you would agree to, is to take out reasonable expenses so that both parties are on their own dime, so to speak, if they do take an issue to arbitration or to court. So that's what that change would do. Okay. Moving on to page 5. This section includes enforceability related to the United States, and as the Chief mentioned, much of what we sought to do was to agree upon how things would proceed pre-recognition. In other words, if Delaware were to pursue, and I understand they have the intention of pursuing, recognition under the Oklahoma Indian Welfare Act, how their resolution and request would go forward, and that it would go forward binding themselves to this MOA and asking the Bureau of Indian Affairs to observe this MOA. Because a tricky part of all of this is that since we don't have a congressional act that lays out all of these things, Interior is not a party to it, and Interior is not necessarily bound to it. So the closest thing that we could come to it was to bind our relationship and our dealings with Interior as it relates to this. So that's what we're seeking to do here.
Ms. Lori Jordan?
Tell me now, what was our reason for leaving out of this agreement any right of recovery on reasonable fees if they breach this contract?
Well, sort of because it goes both ways, that they could seek attorney fees from us or we could seek attorney fees from them. It's kind of a judgment call as to whether you all want to go one way or the other. After seeing the speaker's comment, the Chief agreed to just simply take them out so that each party would be on their own expenses, and they've got some skin in the game, essentially.
I guess I would direct that question then to the speaker.
Yeah, and what I asked him was, under this section BEB, reasonable expense can be awarded. Is this, the way I looked at it, is this a potential implication that damages could possibly be awarded? And that concerned me. Is there an implication there that could happen? And
So did you want to just cut the damage amount out, or the amount that it takes to get us to a point where everyone adheres to the contract or adheres to this agreement?
I want to cut the implication out. Chief Smith, did you have a comment?
Of damages, or, I mean, say we have to enforce this agreement and we expend funds and time of our attorneys and money to file, or if we go to arbitration, we incur cost of arbitration. I totally agree we don't want money damages, but do we not want to make ourselves recover those reasonable expenses if we were to have to do this? Because a lot of times the fact that they may have to pay someone's fees deters them from violating an agreement to start with.
Well, actually, that's probably the precise reason I thought we should have no expenses, is that you got how many lawyers in here? You got a lawyer on the payroll, they invite litigation. So this was probably the way to discourage litigation, since attorneys are happy to pay by their own clients. And that's really the policy issue. We really want to try and negotiate these things out civilly on a government-to-government relationship rather than create incentives for litigation. But that's the entire policy issue. And if you think it's would discourage litigation by putting expenses in. It's just sort of a judgment call.
I mean, I just throw that question out to the group that if you have to enforce it, we traditionally seem to spend a lot more money than everybody else in trying to enforce something. And if we expend $100,000 to get us back on track with this agreement, it seems like we ought to have a pocket to go to.
My experience has been civil rights. If there wasn't a possible right of recovery under civil rights, federal civil rights actions, litigation would go down tremendously. And so, like in a tort claim, a contract claim where you don't get your attorney fees, there's a greater incentive not to litigate than taking it on a contingency and thinking that the other side will ultimately pay your fees.
Just one other question.
Okay, I think their attorney may have had a comment. He was trying to cut in there.
Tom?
Guess not, sorry. Go ahead, Tina.
I note in here where they're agreeing not to attempt to put land in trust for the chief of. Okay. I note in there where they're agreeing not to put, or attempt to put land in trust, but let's say they attempted to do so. We know from other fights that's a long process to try to head that off. And we don't think that's ever going to happen. We've got a good agreement here, and we assume everybody's going to adhere to it. But then there's always the future. You have another group come in that doesn't quite feel the way that the present group feels. And let's say that they take a position that, well, we don't like that part of it, and we're gonna attempt to do that anyway, and we expend a lot of time to keep that from happening. I'm playing the devil's advocate here, guys, because I really don't have a feeling one way or another on this issue. I'm just throwing it out that we've had a continual fight with someone else on this very same issue. We've expended a lot of time, a lot of money, a lot of effort, probably into the hundreds of thousands of dollars. Do we really not want the ability to recover that if we have to expend that kind of time and money?
Well, let me just.
And I just throw. I know. I agree many times.
Let me make their case for you. You know, we had this pretty much substantively this offer on the table 10 years ago, but a group said no, we want to do something different. So we spent, I don't know, $5,800,000 in defending this case. So I mean, your consideration is well taken. I don't have an advocacy position in this. That was a consideration of the body. We certainly would yield to the will of the body under this public policy of whether attorney fees and expenses should be included or not.
I think if we spend $100,000, they're going to spend $100,000.
Well, no, that's not, I mean, I respectfully would disagree. A lot of times we see them spend a lot less than what we spend for some reason or another. I would just suggest to you as a body, are we not doing due diligence for our people if we don't have some form of recovery in any agreement that we make?
Do you want to suggest an amendment?
You might just want to put that same language back in.
As long, I do agree with the speaker though, we really don't want to go to the issue of money damages. We just like to recover what it takes to put us back on track and everybody adhering to this agreement.
Well, if that's the
reason
I'm not
we
advocating,
spend
but if that's what you really want to do, you may want to add that back in. It says reasonable expenses, and that's sometimes a nebulous term because generally in the recovery statutes it's expenses and attorney fees. Expenses sometimes just restrained to court costs and litigation expenses excluding attorney fees. So if that's really what you want to do,
we might want to put reasonable expenses and attorney fees then, but somehow preclude us from a additional damage amount over and above that.
I think there's language in the agreement that prohibits damages.
Yes, there is. And that's what I was concerned about. Mr. Hoskin has a comment.
Just following along, I mean, if you, it's kind of redundant, but if you put strictly limited to reasonable expenses and attorney's fees, that would just reinforce that the parties are crystal clear that it's limited to that.
I'm just trying to think that down the road, this is something that's going to be here for a
Okay,
long
why don't
time.
you propose some language?
I would propose, as the chief just said, that we add back in, prevailing party would be able to collect reasonable expenses, including attorney fees.
Including,
Yeah.
Mr. Henry?
Yes, the actual language would be, what that was deleted, which would read, shall impose upon the violating party an appropriate sanction, comma, which may include an award to the other party of its reasonable expenses incurred in having to participate in the arbitration. Now, the original language just said reasonable expenses. Now, do you want to add reasonable expenses and
So there's no
attorney fees?
question I would add the attorney fees, but I like the word that Counselor Hoskins just used, I don't remember.
I would probably write it, if the dispute is the arbitrator shall impose upon the violating party an appropriate sanction which shall be strictly limited to an award to the other party of its reasonable expenses and attorney's fees incurred in having to participate in the arbitration. I think that would do it.
I think that I would limit us just to
Limiting it
fees.
to arbitration? Mr. Hoskin?
I wouldn't put just arbitration in there. I would stop.
You could just put arbitration.
I would stop after reasonable expenses and attorney fees.
Okay, not, yeah.
So it's not
Allows you to cover both.
Mr. Embry?
Well, and obviously, if the attorneys on the Delaware have any comment or objection to the language going on, I would ask them to please speak up. But my opinion, if you're going to have reasonable expenses and attorney fees on arbitration, this provision also allows one to go to district court. So you would have the prevailing party have that same remedy in federal district court.
Mr. Hoskin?
Yeah, having to participate in a matter concerning the enforcement of this MOU, or you could just specify arbitration. I agree with.
I just wanted to make sure Melanie was the chief in agreement with that wording.
Yeah, I believe so.
Okay.
So let me just read it back quickly. Shall impose upon the violating party an appropriate sanction, comma, which shall be strictly limited to an award to the other party of its reasonable expenses and attorney fees, period. Is that what I said?
Yeah, and then stop, and don't add that last part. That gives you two different avenues, whether you go to court or whether you go to arbitration.
Melanie?
And should that become I think that should become a new D under this section so that
It's
it's
clear.
not tied to the arbitration part.
Did their attorney have any input?
I think that's a good idea to add it in a separate paragraph D, so that it does apply to both the arbitration aspect of that and also the litigation.
Okay. Ms. Closure?
Just a question to Vicki.
Yes, I'm sorry.
Would your people, do you think your folks would be in agreement to that wording?
Yes, are they on the line still, or do we?
They're
I'm
on the line.
not sure whether we're getting them on.
But we're not sure we can hear it.
Chief? Chief? Tom? We don't have them.
I'm here.
Oh. Is that Tom?
That's Chief Douglas?
That's Tom.
I'm here. Okay.
Okay, Tom, you agree with that?
If we do move it out of that section, we're changing what we originally intended, and that I don't think that's necessarily problematic. But for example, we need to amend the arbitrator's language to the tribunal or something like that. my understanding of the agreement is that, that fees and costs would be available in a court action in accordance with the normal rules of attorney's fees in court, which generally under the American rule means each party bears their own, but in instances of bad faith, and that's really what we're talking about here, in instances of bad faith, fees can be awarded. Steve Smith, do you agree with that characterization?
He asked me a question. Oh, I'm sorry, Tom. You're right about the American rule. That there would have to be a showing of bad faith, exasperation of attorney fees, that sort of thing, in order for the prevailing party to win.
And that's basically what this provision was intended to do with the arbitration too. The parties would share the arbitration expenses, but if one tribe or the other is acting in bad faith, and then fees and costs could be imposed as a sanction. I don't see any real problem if you want to move it down and make a new deed, except that we would have to change the wording a little so that it would reflect an award by the tribunal as opposed to the arbitration.
I would put that in the form of a motion then, what we just discussed.
And you want to read your,
I'm going to defer to Melanie there. I think she has a better written. I'll second your
what she's going to read the motion.
I ask one question before I read it. Where it says shall impose upon the violating party, do we want to leave that shall or make it permissive?
May or shall? Mr. Hoskins?
I was distracted by Council Ford. Yeah, you can repeat that.
Melanie asked the question, shall we use shall or make it more permissive?
Mine. Or shall or mine.
Before impose. Yeah, I would agree with that.
May or shall?
I'm sorry, may.
May. Ms. Gloria Jordan?
I have a problem with that. Well, shall means you have to do it every time.
Put arbitrator / tribunal.
And Ms. Gloria Jordan, you're deferring to Melanie to read the
Yes,
proposed read the
now that we've
motion.
added that word may.
Okay, let me take a stab at it. If the dispute is found to have been initiated in violation of the subsection, the arbitrator / tribunal, upon request or upon their own initiative, may impose upon the violating party an appropriate sanction, which shall be strictly limited to an award to the other party of its reasonable expenses and attorney fees, period.
Is everyone clear? We
It
have a
will become a
motion.
new Part B.
We have a motion and a second. Any further discussion? All in favor, signify by saying aye.
Aye.
All opposed, same sign. Okay. Okay, moving on.
Moving on. The next question that came up was on page 5.
May I ask a procedural question? Do I have to accept that since I'm the sponsor? Do we just vote on it?
Yes, I'm assuming you will, right?
No.
it's not an amendment, it's a motion.
Yeah, if it's adopted by the body, it becomes part of it. Now, you can choose not to sponsor it. You know, but no, you don't have the.
I accept that. I just want to be.
But no, I mean, you know, in a vacuum, that's the way it would happen. If an amendment passed on someone's piece of legislation that made it abhorrent to that person, and they no longer want to be part of it, they could withdraw as a sponsor from it, and that'd be their remedy.
All right, Dr. Cobb? Go ahead,
Just
Melanie.
also procedurally, I don't know how you want to address the other changes I'm proposing on the floor. So if there are changes I'm proposing, like the one that we covered earlier, that are acceptable, I don't know if you want to just vote on them all together at the end or what, but that's, just wanted to raise that too. Page 5, and it's at the top of page 5, item 6, called choice of law. There was a question about a possible conflict between this. As you read this, it says that the application of the laws in the nation or tribe can be applied as it relates to resolving disputes on contract questions. There is another section under B2 of the same section that comes on page 3. If you look at little b, item 2, it says at the last sentence, each party also agrees that it will not interpose as a defense or otherwise any failure to exhaust tribal remedies by the other party in any action filed under this part. And the question was whether those two conflict each other, because one says that you can't interpose tribal remedies, the other says that the tribal and nation laws apply. And the difference in these two sections is this, that B2 comes to the issue if either party were to raise a defense that it didn't go through their tribal court system first or exhaust tribal remedies first before going to federal court or to arbitration, it couldn't be raised as a defense. So in other words, we couldn't say, well, it's got to go through our tribal court before we can proceed in this other venue. So that's what B2 means. And then B6 deals with law and its application, and that tribal and nation law would still apply. So one is a defense and one's application of law. So I just wanted to address that one. And please stop me anytime you need to ask Dr. Tom.
I just want to be clear. This doesn't limit our ability to have this go through tribal court? I mean, one's a defense, I mean, that's what I'm...
It does. It does,
to what extent is what I want to know.
Because we've agreed, by way of this agreement, as I understand it, to participate in a third-party forum, whether it be arbitration or whether it be federal district court. We agreed to basically play in neutral territory, and so did they.
Okay.
Yeah. Okay, the next section on page 5 is enforceability as it comes to the United States. And as I said before, the Delaware tribe will pursue by way of a tribal resolution, I believe that they've already passed, right, Vicki, to request reorganization under OIWA. And what our intention in this section was here was to bind the United States as much as we can in terms of how they recognize the Delaware under OIWA. In other words, there are some restrictions on that as it comes to playing within the jurisdictional boundaries of the Cherokee Nation. Now, as the chief said, outside the Cherokee Nation, we didn't intend any restriction on our part, so that they could be as a tribe and enjoy all the rights and privileges thereof outside the Cherokee Nation, just like any other tribe does. But within the Cherokee Nation, since it's our jurisdiction, that's the reason we put these parameters around here. With the United States not being a party to this agreement, it makes it touchy, because they're not necessarily bound by this, because they're not signing this MOA. We don't have a piece of legislation that says the U.S. government has to do these things. But the best that we could do is to bind the Delaware tribe in its dealings with the federal government and our dealings with the federal government in coming to this arrangement. So that's what this section deals with here, is mostly pre-recognition. How are they going to request recognition and organization and so forth. So there was one comment that the speaker made, and we just wanted to add just a little phrase there. It's item C3, and it's just providing a person to provide a copy of the approval from the Secretary to, and that copy would go to the Secretary of State, just so that there's a receiving person on this end to accept the copy. So I'd be happy to answer any questions about this section.
We have somebody designated on the Delaware side.
On the Delaware side, there isn't someone designated. But the secretary would be dealing directly with the chief, I assume, on the Delaware side for OIWA.
This is providing you guys notice.
But it's getting us the additional copy of their decision. Any other questions about this portion?
Any questions? Give you on, Melanie.
Okay, moving on to jurisdiction. And this one, I'll acknowledge, becomes complicated, and was complicated for me because there are sort of two ways to look at jurisdiction, and I try to simplify it. One is territorial types of jurisdiction, and another is a governmental type of jurisdiction. So generally what we sought to do here is that, again, because the Cherokee Nation has jurisdictional boundaries over 14 counties, exercising territorial jurisdiction, like over criminal and civil law that's tied to a nexus of territory, as they say, we wanted to preserve the nation's right to that jurisdiction within the 14 counties. So that is the reason this is worded the way it is. The second half of that is governmental kinds of jurisdiction, and that can be jurisdiction over your own governance, like your own elections, your own membership, the internal workings of the government of itself. And we didn't want to limit Delaware's ability to govern itself on its own issues like that. And so this specifies that that kind of governance is retained to the Delaware Nation no matter where it occurs.
Oh, Dr. Cobb, sorry.
Part 3, Section A, last sentence of Part 1. Federal recognition of the tri-state reorganization under OIWA or by any other means.
Yes.
I just want to know
Where that came from?
by any other means, and does that leave us open to something we missed?
What this, that little phrase was intended to do was to bind us to this agreement no matter what reorganization comes in the form of.
We being both of us.
We being both of us, whether it happens under OIWA or whether it happens in the form of a congressional act later that we didn't anticipate when we entered this agreement. So the Sullivan bill has been introduced. It probably won't get past this session of Congress. A new bill will have to be introduced next session of Congress. And will it be the same bill? We don't know. And so we want to make sure that we're still bound by this, even if recognition comes in the form of a congressional bill and not OIWA. So that was the purpose of that phrase.
So,
Melanie, you brought it up that there will be a new bill introduced, and so what's the timeline are we looking at as far as the Delaware tribe expectations for receiving federal recognition, provided everything goes as planned and unobjected and so forth? Is there, you have a timeline?
I'll respond to that, and then I'll allow Vicki to respond to that. I'll just briefly, as I said, the bill that's on the table doesn't have time to pass this session, so there'll have to be an identical bill proposed again next session. Is the bill critical in order to get OIWA recognition? I think that's a question. I think that the Department of Interior has at least indicated to the Delaware tribe that if they had agreement from both parties, us and the Delaware, they may be willing to proceed with reorganization under OIWA, even if there's not a Sullivan bill on the table. So I think that they are looking at, once an agreement's in place, moving forward with Department of Interior with that agreement and seeing what Interior can do in response to it. And I'd allow, Tom, do you have any comments to that question? Did you hear it?
I did hear it, or at least most of it, and I heard you very clearly. And Interior has indicated, so long as the two tribes are in agreement, that it is likely to be willing to move forward under the OIWA without legislation. And our hope is that before this administration is over, they will have at least approved the tribe's constitution and scheduled the secretarial election. the draft legislation that Congressman Sullivan introduced in August, and he did that knowing that it would not pass this year. There wasn't time to build the kind of consensus to move it this year. But it reinforces, but is not necessary to the OIWA. It does include provision expressly making the MOA binding on the United States, and the MOA says that we'll push to get that provision included in legislation. And on the tribe's behalf, we're grateful that the nation has been supportive of our moving forward under the OIWA, because that kind of willingness in the department is always subject to the shifting political sands, and there's no guarantee that a new administration will be willing to do it. So the timing of this is important, and we are very grateful.
We're talking months then?
Anything else, Mr. Stoke?
No, thank you.
Okay, Melanie?
Moving forward on through the jurisdiction section, as you can see, at first we have a jurisdiction generally, some statements about jurisdiction generally, and then we have a specific section, section 3 on page 7, that deals with jurisdiction within the Cherokee Nation jurisdictional boundaries, which we wanted to make more explicit, of course, because that's our interest. At first, there's a general statement: the tribe shall not exercise jurisdiction within the Cherokee Nation jurisdictional boundary, period. And then there are some exceptional statements, and you can see what those are. Nothing in the introductory paragraph diminishes the general authority of the tribe to control and regulate its governmental affairs, and we talk about taxation of its entities, elections, and membership. In essence, even if we tax an activity out there that Delaware tribe does, they can tax it in addition to our tax if they wish to. They can tax it in addition to state tax if they want to, and we didn't want to preclude that from happening. And then the last statement of Part A there: in any circumstance in which that authority is not dependent on the territorial jurisdiction on or the location of an activity. In other words, again, getting back to territorial jurisdiction, preserving that to the Cherokee Nation. So there was one question that the speaker raised in terms of the example of license plates or car tags, and whether the Delaware tribe could sell license tags in the Cherokee Nation. And my response to that is, because A says what it says and limits them to jurisdiction that's not dependent on territorial jurisdiction or the location of an activity, my answer would be no to that question. That selling tags has to be dependent upon a jurisdictional area. Whether you're in Oklahoma, Arkansas, or Cherokee Nation, you have to have a jurisdictional boundary in order to do that. So you have to have a territory. So my answer to that would be no.
Oh, I'm sorry, Dr. Cobb.
I facetiously say your answer to that is no, but tell me the possibilities of somebody else's answer.
Well, I
know how you're reading it.
Well, we can ask Tom of his opinion of this section, and then I would assume that if his answer is also no, then anyone who, if the Delaware's understanding is no, our understanding is no, then if someone says yes, it's a breach of the agreement. So, Tom, what's your answer?
My answer independently was also no this morning when we got the speaker's comment. And I have never heard of a license tag scheme that wasn't based on territorial jurisdiction. As I said to Melanie this morning, well, we can't issue tags to Delaware members in California and expect California to accept them, because there is that nexus to where the car is.
Yes, I think if you look at the Potawatomi case, that was the basis for tribal car tags. It says it must be garaged in any country.
And we don't have jurisdiction over Indian country within the 14 counties the Cherokee Nation does. Somebody could argue anything, but I guarantee you under this agreement that they would lose.
Can you,
Mr. I'm sorry.
I'm sorry.
Mr. Hoskin?
Well, nobody could disagree if we were explicit about it. I'm not making a motion, I'm just...
That's a good comment. Dr. Cobb?
On my, not being an attorney, walk me through, and I know this is a complicated question, I'm not looking for a complicated answer, but not being an attorney, walk me through the steps of, the Catuas don't have any jurisdictional boundary either, and they're selling car tags, so walk me through how that's gonna.
Okay.
Walk me how this is different is what I want to know.
I think the AG is just chomping at the bit.
Chomping
to
at
answer
the bit. Come forward, Ms. Hammond.
Chomp on these, don't chomp on me.
The case that led to motor vehicle licensures is called Citizen Van Potawatomi, involved Citizen Van Potawatomi. The holding of that case is that motor vehicles that are principally housed on Indian country, principally garaged on Indian country, are not subject to taxation by the state. That's very simple. Our agreement with the state is much as like it is with tobacco and those sorts of things. We come to an agreement with the state, and the state assumes that all the vehicles that we tag are principally garaged on Indian country. You have to have that Indian country to be entitled to do that. Why did the Catuas do it? The simple answer is because nobody enforces the law. There is a specific Oklahoma Attorney General's opinion regarding it, and we have been fighting with not a whole lot of success and varying degrees of effort, to tell you the truth, with the Department of Public Safety, local DA's offices, all those folks, to try to get that enforced, because they have no right to do it. They also have no right to game on fee land. The difference in, I think, this instance and the Delaware agreement is that we are explicit. They understand that, and they're not making a claim that they're us. And that's what the Catuas do. They say, we are the historic Cherokee Nation, so we have the right to do it. This is all our land. So, is that
It will give back, I will give this back to Councilor Hoskin, and specifically with the word explicit is what I'm looking for.
Well, I'll yield to the chief. I'll give it to the chief.
The other thing that differentiates this from the UKB, because they're a federally recognized band, they have sovereign immunity, so we can't sue them directly. Under this agreement, we do have the right to sue the Delawares directly if they do issue car tags. So we have a right, a remedy, and a way to enforce it that we don't have with the UKBs.
Mr. Hoskin?
Was it ever on the table that car tags should be explicit? Because it seems to me if there's a meeting of the minds that car tags is not something that they can do within the meaning of that paragraph A, then I guess either side would disagree if we were explicit about that. But was it ever on the table?
It's never been discussed other than what you've heard today, and I think both sides would be satisfied if you'd like to offer some language to say, for example, car tags.
including the housing too.
I think you can throw in there, Mr. Hoskin, gaming potential also is a consideration.
Before we do, are the Delawares, I don't want to negotiate this, but are the Delawares, is that acceptable? I mean, I heard the council's answer when he talked about his independent answer this morning, but I just want to make sure he's...
D'Souza, you want to come forward?
What the determination would be was, would this be considered a major change? One that has to go back before our tribal council all over again.
It wasn't a change, I think, from the intent, but.
Right.
Yeah.
Tom? Tom, are you there?
I don't think this is a change. If you wanted to have that example, I don't think it's a change at all because I think it's what we intended all along. And I actually had thought of car tags as one of the things that that would be precluded to the tribe unless it got express permission from the nation because it is territorial based.
Just like gaming.
Well, gaming is already strictly prohibited under a separate section. So I
Right.
think gaming, it would be redundant.
Yeah, they're not concerned about limiting.
So then, what I'm hearing you say on your end is you don't think there's any problem, or you don't have a problem with putting, for example, license tags?
I think we've already agreed to it. I can't speak for Chief Douglas, but that's my understanding of what we negotiated.
Tom, can you hold just a second? Mr. Hoskin has it.
Yeah, I mean, sometimes less is more. We could probably sit all day long and do a laundry list of
Right.
items. Car tags is the most apparent because it's in our face every day. So I'm not going to make the motion that we put the language in, but I'd certainly listen to some other thoughts on it before we go any further. Because I'm just right now not prepared to say we need to list every single thing, but I like to ask Mr. Hembry's opinion.
Well, usually, in a memorandum like this, you paint with broad strokes as much as you can. I would agree with language that was suggested that included, not limited to, the issuance of car tags. I mean, we can make a laundry list of things such as smoke shops, et cetera, if you want to raise that issue. But if your idea is very specific to car tags, I would say included but not limited to the issuance of car tags would be my recommendation. Now, gaming is covered later on in the memorandum, and I wouldn't put anything about gaming here, but would deal with, if you have any questions about the gaming provisions, it's later on in this memorandum.
Where would you suggest the language under the C, the in general? The tribe shall not exercise jurisdiction in the Cherokee Nation jurisdictional boundary, including but not limited to?
C with little c,
Right.
page 7. Tribal jurisdiction within the Cherokee Nation jurisdictional boundary in general. No, I would go to 1A.
You go to 1A.
Yeah,
Okay.
at the end of 1A, right before or. It's not dependent on territorial jurisdiction or the location of any activity, including but not limited to the issuance, whatever, I'm not an English major, the issuance of car tags.
Mr. Hoskin, are you comfortable there?
I just don't know if you read that, it says diminishes the general authority of the tribe to control its, nothing shall diminish the authority of the tribe to control and regulate its governmental affairs in any circumstances in which that authority is not within the territorial jurisdiction of the location of that activity, including but not limited to car tags. And it starts to sound like we're conceding that that's not dependent on territorial jurisdiction. So I don't know if I'm ready to do the motion, but I would say, in general, the tribe shall not exercise jurisdiction within the Cherokee Nation jurisdictional boundary, including but not limited to the issuance of car tags.
And where are you at?
That's right above. It's sort of the summary of C above 1, above effect on tribal authority. I mean, that sets
Which
forth,
is in general.
yeah, that sets forth the limit, and then 1 sets forth the exception.
I would agree with you, sir.
Chief Smith, did you have a comment in regard to that, or Ms. Hammond?
Thank you, Madam Speaker. Mr. Hoskin, I was wondering perhaps if we could revamp 3, taxation and regulation, and put it in there somewhere. Because of course, that's what it is. Motor vehicles, taxation.
I think
And
that's,
Right, that broad statement in general, I'd hate to
I
do anything that might
I agree
include
with
that.
that 100%. I agree with that 100%.
Okay.
And let me explain a bit about the taxation and regulation, because as I said, and the example of smoke shops came up, and I think that the tendency would be to say no smoke shops either, but what the intention was on, specifically on business activities, is that they could tax business activities at the tribe, but they're still under our jurisdiction. So they've got to get our license, they've got to pay our tax, but if Delaware wants to impose another tax on that, then that's their ability to do that. So that was specifically discussed and agreed to.
Ms. Ross, can you still have the floor?
Mr. Hembry, do you see I'm looking for some assistance if we're going to amend 3.
On the taxation part,
Would we just put a sub-paragraph in there?
let's read it together. This subsection expressly permits the nation to tax and regulate activities of the tribe, including Delaware tribal businesses, within the Cherokee Nation jurisdictional boundaries that are otherwise taxed and regulated under the nation's code, regardless of whether the activities are so taxed or regulated by the tribe. Provided, however, that the nation agrees that it will not tax or regulate such an activity if the activity is subject to comparable taxation or regulation by the state.
If you had to add a sentence.
In what, we could say, notwithstanding this, any provision in this paragraph, the tribe is restricted from the issuance of car tags. And I'm going off the top of my head here. I would do some kind of qualifier like notwithstanding or,
Any other provisions herein or whatever?
yeah.
Madam Speaker, this
Yes,
is
sir.
Tom.
Okay, Tom, you have the floor.
I wonder if we should add a sentence at the end of number 2, governmental activities, rather than 3, taxation and regulation, specifying that issuance of tags has a territorial nexus and therefore is not such a governmental activity.
Since.
Rather than trying to include it in 3, exclude it from 2.
Mr. Haas, are you comfortable with that?
That makes sense to me.
Okay with you?
Yes, Your
Ms. Hammond?
Your Honor.
It is. Hi, Tom, this is Diane Hammonds. How are you?
Hey Diane, how are you?
Fine, thank you. I thought that perhaps, and 2 works, I believe, as well as 3, I think perhaps if we maybe include a new sentence and reference that last phrase in 1A, perhaps something like specifically the tribe is, I was putting it at 3, so that's the way this wording works. Specifically, the tribe is prohibited from exercising any or tax or regulation that is dependent on territorial jurisdiction or the location that is dependent on territorial jurisdiction or location of the activity, e.g. the issuance of motor vehicle tags.
I think that's fine. I think it works better in 2, but I think
That's
it's better either way.
Fine, that's fine.
Mr. Haas,
Which EG with including but not limited to, and I think that's...
Right, including but not limited to. One of the things that we want to not do is when you start laundry listing, then it can be construed, if you didn't include it in the list, it's not included. So including but not limited to is important.
Dr. Cobb?
No,
You have a
thank
question? Okay. Charles, can you just read your motion?
It will be once we probably get it read back and Madam Speaker, I don't have good notes on what was just said.
Melanie, did you want to read that back so that we have a clear understanding? This is under
This is under,
Number 2?
yes,
Okay, governmental.
1B2 on the front of page 8. Governmental activities, last sentence. Specifically, the tribe is prohibited from exercising any tax or regulation that is dependent on territorial jurisdiction or the location of an activity, comma, including but not limited to the issuance of motor vehicle registrations.
Let's put that in form of a motion, Madam Speaker.
Have a motion, do I have a second?
Second.
Moved in second, any further discussion? All in favor, signify by saying aye.
Aye.
All opposed, same sign. Do we have a quorum? 1, 2, 3, 4, 5, 6, 7, 8, 9, okay. All right, Melanie, got that one? Okay.
Okay, the next section is D, tribal and individual land, and this deals with land in a trust. Again, as is with the rest of this part of this section, we didn't want to restrict land in the trust outside the jurisdiction of the nation, so at first it makes broad sweeping statements about their ability to acquire land in the trust and wanted to make sure that was in place. Then 2, trust land within the Cherokee Nation jurisdictional boundary. The tribe will not seek and may not obtain land held in a trust by the United States within the Cherokee Nation jurisdictional boundary by any means. So this again was intended to limit congressional acts and limit administrative acts and so forth. Item 3, Indian lands for gaming within the Cherokee Nation jurisdictional boundary. 1, we thought it was important to specifically limit it. May not conduct gaming under the auspices of the Indian Gaming Regulatory Act. And again, it was to specify that just because you have land in the trust, we do have another tribe that's claiming you don't need land in the trust to exercise, to operate a gaming facility. So this is to specify that they will not perform gaming under IGRA within the Cherokee Nation.
Dr. Cobb?
I'd like to have a little bit of discussion about the last sentence in 3, written consent of the nation.
Yes.
Is there any thoughts from anyone else about making that a little bit more detailed as far as administration and the executive branch of the Cherokee Nation, both passing those?
I have, we did consider that,
I thought we took
and
it out.
it's on the top of page 9, it's item 4.
I couldn't find it, that's why. Okay.
And that was purposeful so that a chief couldn't just simply sign a letter giving that ability over to the Delaware, but that it had the agreement of both branches to do that.
I thought it was in 3, I missed it.
And in fact, right now it would require a change of our statute as well as the written consent, because our statutes don't allow it presently. So our statutes restrict gaming to us. We can't even give it over to individuals at this point. So.
Questions, comments? Yes. Ms. Hembry?
If it doesn't meet with much consternation, on number 2, trust land within the Cherokee Nation jurisdictional boundary, would there be any objection to changing the word may to shall? The tribe will not seek and shall not obtain land held in trust by the United States by any means, is a little bit more definitive language.
Got a motion, a second?
Yes.
Any discussion? All in favor, signify by saying aye.
Aye.
Opposed, same sign. Okay, Melanie?
Moving forward. Part E, organization, membership, and assets of the Delaware tribe. There was a bit of complication because the Delawares were recognized and then became not recognized, and it complicates things because they received certain things as being a tribe, and then they weren't a tribe, and now they're proposed to be a tribe in the eyes of the federal government. And so what E is trying to do is to deal with some of that. 1 is disclaiming any interest of ours in their governing documents or law, membership, and that sort of thing. Item 2 is specifically disclaiming interest in funds that they've gotten in litigation against the federal government. So they have settlement funds that are out there waiting to be distributed that were won in various forms of litigation, and we don't have any interest in that. That should be distributed to their membership and so forth. Whether they have trust funds that are sitting out there that are Delaware's and have been as a result of claims from their old prior lands in Kansas or old prior lands in Delaware and so forth, that's the kind of thing that we're addressing in 2A.
Dr. Cobb?
Chief, this is for you. We've had this discussion. I'm not putting you on the spot. I just want kind of walk me through the thinking on allowing dual citizenship, because this section goes to membership. And I know we do that. I just kind of want to lay out. I'm thinking down the road, if that ever changes and we have an MOA here that basically says we're not going to, we don't have any interest in membership. So I know we've had this conversation, and I'm not, but I just want to kind of lay out our thinking on allowing dual citizenship and kind of where you see that going in the future.
By our Constitution, we say anybody who can trace back to the Dawes Roll, including the Delaware and Shawnee members, are entitled to citizenship. And so we have never gone beyond the constitutional confines and say if you were a member or eligible for membership in more than one tribe, that you had to elect. You could say the same thing about, we've always had open membership of the UKB and the Shawnees and all the Delawares. It could be the same with the Creeks and Osages. It's just where the foundation of our Constitution lies. I think that's pretty much the constraint. Other tribes can do what they want to. If they want to create exclusivity, I don't think it hasn't been our policy, and I don't know that it would be authorized by the Constitution.
Thank you. Appreciate it.
Chief Smith, can I add something? This is Tom.
Yes.
The right of Delaware's to citizenship in the nation was also expressly dealt with in the 1867 agreement. And one of the things that was a guiding principle in negotiating this MOA was not disturbing the fundamental terms of that agreement.
Well, we've seen the Shawnees create an exclusive role, and basically my understanding is that once you're federally recognized, that's your right. So it's sort of beyond our decision making.
Mr. Baker?
But if there are Delawares that want to stay Cherokees, that's permissible under this?
From our side, absolutely.
Absolutely, okay.
Essentially, what this does, it doesn't disturb that, but if some point the Delawares chose to amend their constitution, they could do that and prohibit dual enrollment in their own constitution, if that's what they choose.
Okay. Anyone? Does that answer your question, Dr. Cobb?
Okay. Item E2, little b, or big B, that is disclaiming any interest of ours in funds or property that they received by the United States while they were recognized. And let me get to what that was intended to do. They had grant funds, they had, as I said, trust funds or settlement funds, then they had tribal funds, and I'm sure other sources of funds that they used to buy property. And some of those, for the example, let me give an example of an ICDBG grant, for example, where they can do construction, they can buy land associated with that construction. What we intended to do with this agreement is that those properties did not have to be given back to the federal government in some way, or that we had any interest in them, but that Delawares could retain those properties, such as what their wellness center sits on, that was constructed, I understand, with ICDBG, that we would have no interest in those. They had no trust lands before they were unrecognized by the 10th Circuit. So there were no lands that we feel like are Indian country for purposes of our jurisdiction, nor would we have any interest in. They were fee lands that they had acquired over the course of being a tribe, and sometimes acquired with federal funds, and that's the reason we wanted to include that here. It's just because they were federal funds purchasing those properties, and it may be personal property as well, like equipment. They had some medical equipment in their wellness center that we didn't have any interest in trying to attach that equipment, so that could remain with the tribe and they could use it to provide programs and services. So any questions about that section there? Okay. Moving forward to, now we get into programs and services. And essentially, just as a general overview of this long, very long section, what the intention was to do was to go almost funding source by funding source and talk about various programs and services. What we tried to avoid is competition with the nation unless we consented to competition on grants and contracts with the federal government. We also did not want, and as a result of Delaware's being not recognized, what we've done in the interim is that, in the example of child care, housing, and some other services, we've become a sub-awardee, or they've become a sub-awardee of ours, where we pass through money from the federal government to Delaware's based on their population. So in the case of child care, the Child Care Bureau took that money that they were formally granting to Delaware, gave it to us so that we could subcontract with Delaware to keep those 3 child care centers open that they operate. So we didn't lose any money in that instance, but what we did was become the grantee because they were no longer recognized and could no longer do that function. So what we've done in this programs and services area is that we try to preserve those things that we've already agreed to pass through, like housing, child care, and some BIA money, all of which did not carve out any additional dollars from Cherokee Nation. So what we're doing is not losing the money to the Delaware population. So we're passing those through to the Delaware tribe. What it also tried to address is grants that come up every so often that we wouldn't compete against each other unless we knew about it and that we consented to it. So that we wouldn't be stepping over ourselves trying to serve the same service population and competing with each other on the same grant. And so that's what this section is attempting to do, is to address some of those things. Also what it does is sets out what are the federal requirements that we have to abide by and that they will in turn have to abide by if we pass through any money to them as a sub-grantee. So all of this section deals with those things. So I'll just go through it really briefly because I know it's a long section. The first sections are general in nature and statements that their members, because they will be federally recognized tribal members, will be eligible for services from us on the same basis as other tribes members are. So if we have a program that serves all federally recognized tribes, we will also serve their members as a member of a federally recognized tribe. So very general statements that they're eligible for those programs. Administration by them under F3. Within the Cherokee Nation jurisdictional boundary, again restricting it to our jurisdiction, the tribe would be eligible to apply for and administer programs and services if we enter into an agreement regarding the tribe doing that. Yes.
Thank you, Madam Speaker. I had never thought about it, but how do they define their citizenship? Is it not by the Dawes rules as well?
I think they have a base role. For the base role, it's probably based on Dawes, but yeah, I think there's an additional members that weren't on Dawes, but not many,
But they're not.
So there are a few Delaware citizens that are not also citizens or eligible for citizenship with us, but there are a few.
But they're on some kind of official documentation. Yeah. There's not like a new role created.
No. And in fact, under OIWA, when they create their constitution and have their secretarial election, they're going to have to identify that base role and get approval from the secretary on how they do their enrollment function.
Much appreciated. Thank you.
Essentially, one, they could apply for grants and contracts if we agree. That's one provision there. And or we could determine that we're not eligible for a grant, but they might be eligible for that grant, and so we would let them know that, but we would be notified and have a documentation of that in writing. And then there's a provision in 3 that if we don't object within 30 days to them notifying us that they intend to apply, that they can go ahead and apply for that grant. And that's just to prevent any inaction on our part to prevent them from applying for a particular grant. The programs and services section, 4. And this just goes through federal programs, state programs, and so forth. Our intention here was to be very broad because there are some federal programs that go through the state, such as a lot of Department of Justice programs go through the state and so forth. So we didn't want to leave those programs out. So those are included. 4C covers cross-deputization agreements. Some issues with some other tribes have been that they intended to enter into cross-deputization agreements, and we didn't think they had jurisdiction, so we just wanted to be very explicit about that. That's our ability to enter those cross-deputization agreements. However, if a county wanted to deputize individuals like they do any other individuals out there, that they could still do that. It just wouldn't be an intergovernmental arrangement. It would be an arrangement with individuals to be deputized. So they wouldn't have a police force or a police office, but individual Delawares could be deputized by the county just like any other individuals could be deputized. Okay, that pretty much goes through those.
Dr. Cobb?
What happens if, I don't know, any housing, let's say 20 years from now, the Housing Authority of the Delaware Tribe of Indians, there's a major problem with the housing development or housing, and it's in our jurisdictional boundary, and we come up and say, look, this is a problem, whether it's structurally, safety issues, whatever, come up with anything. Do we have any recourse to say, look, you've got this problem in our jurisdiction, even though you are administering it? Is there any recourse on that, or?
Well, there is, and it goes a couple of ways. One is we have a sub-award agreement with them that says these are the parameters, these are the requirements that you have to abide by. And if for whatever reason they don't abide by those, there are things that we can do. There are things that HUD can do. We're ultimately responsible as a grantee for everyone that we sub-grant to, whether it be Delawares, whether it be community organizations, whether it be individuals. We're still responsible for compliance. And so what we're doing in the sub-award agreements as well as this agreement is saying you have to abide by 87, you have to be audited, you have to provide us a copy of your audit. All of these things apply, and you're responsible for paying back any money if HUD says you spent it improperly, that kind of thing. So all of those things, again, are in the agreement. Now, what if they fail to do that? Then we have those remedies that we talked about, which really are stronger in this agreement than they are in the sub-award agreements, because the sub-award agreements don't specifically, I don't think, waive any sovereign immunity as it is now. So we couldn't go out and sue the Delaware tribe for not complying with the HUD agreement, for instance, but we could under this agreement because they're essentially saying we're going to comply or else you can apply these remedies to us.
And I know, if I may, I know that we have passed through 100% of everything except on housing. I think out of that $500,000, there's a $20,000 administration fee because we're actually doing the paperwork and the
we're required to do a self-assessment every year.
Is that still?
That's still pretty much.
Going to say that, okay.
Mm-hmm.
All right.
Yeah, we're not proposing to do any additional holdback on any of those agreements for administrative costs or what have you. We're pretty much passing them all through because in the case of the child care agreement, for instance, we've had that going on for a couple of years now, so we have some experience. We have an agreement with them, and of course we make payments to them, and we perform compliance jointly with Health and Human Services. So there's some administration associated with it, but we don't think it's significant enough to warrant, carving out something for us to do that.
Thank you.
Melanie, in 10 minutes we have a council meeting.
Okay. So let's move. That brings us pretty much to all of this sub-award agreement. It provides for notice if we think there's a compliance issue. It provides them the ability to fix a compliance issue before we take any action. They have to provide us with audits. So now we get to item 8, which is on page 14. The things that we can do is we can terminate a subaward agreement. We can, ask them to repay. If the federal agency, say, disallows some costs associated with one of these subaward agreements, then this agreement says the Delawares have to pay for that if it's associated with their activity under the agreement. So what it gets down to is item 9, which is indemnification. And that reads that, if there's some issues of noncompliance on the tribe side, they're indemnifying us for that. So they're responsible for their actions. If there's some noncompliance on our part, then we're indemnifying the Delaware tribe for that. So we're holding them harmless for our actions. So that's a reciprocal indemnification on item 9 on page 14. Item 10, staffing. This was in here just to basically say that we will, wherever we can, try to employ Delaware tribal members in those programs that serve them. So particularly in the town of Bartlesville, for example, that we would try to employ Delaware tribal members wherever we can. And we didn't make a specific commitment, but just a general commitment that we would try to do that wherever we can to provide services that serve them, primarily serve them. Item 11 deals with duplication of services. And then the entire section G goes program by program and identifies various programs that we've already reached agreement upon, various grant opportunities that come down each year, and how we would deal with those. Some of them, like cultural programs, language programs, Native American graves and repatriation programs. We specifically wanted to identify those as being, because there's a specific Delaware language or specific Delaware culture, specific Delaware history, we wanted them to be able to apply for some of those programs independently of us. And so this agreement sets that out. Even if they work in competition with us, we think it's important enough for them to be able to preserve their own language, for example. It deals with health programs, and there's a lot of, there's a whole list of items related to health. There was a wellness facility in Bartlesville, and there's some language in here about that facility, as well as the equipment and how we would agree to utilize that equipment. They've made a commitment that we could utilize their equipment for certain purposes. We've agreed that on the bottom of page 17 that we would jointly seek funding at some point in the future for a new Bartlesville clinic to serve not just the Delaware tribe, but the nation and all of the tribe's beneficiaries that are eligible for health services. Page 18 talks about administration for Native Americans, and that's a grant agency that provides various types of grants. Child Care and Development Fund, I talked about. There are 3 existing child care centers, and we will continue those arrangements to pass through the funding, which is about $1.3 million a year to fund those facilities. And page 19 goes through 4 different funding sources, and what we try to do is identify as many as possible.
Call for the question, unanimous consent.
Questions have been called. All in favor of approving this resolution covering this memorandum of agreement between the Cherokee Nation and Delaware Tribe, signify by saying aye. Aye. All opposed, same sign. Okay, now we will entertain a motion to adjourn. Second.
I move we adjourn.
All in favor, signify by saying aye. Aye. All opposed, same sign. Now we have 3 minutes to get to the council chamber.
Chief
Oh, good. We don't have to.
Chief Douglas, thanks for being with us.